Okay. I'm calling the regularly scheduled meeting of the Natrona County Planning and Zoning Commission to order. I'd like to introduce the Planning Commission members and staff. On my immediate left is Hal Hutchinson. To his left is Bob Bailey. At the end of the table is Tom Davis. My name is Jim Brown. Staff members present are Jason Gutierrez, Development Department Director, Trish Chavez, Planner, Peggy Johnson, Administrative Secretary, and Charmaine Reed, Deputy County Attorney. This commission is an advisory board for the Natrona County Commissioners. Our decisions are subject to approval, conditional approval, denial, or modification by the Board of County Commissioners. Recommendation by this Planning Commission for items 2 to 4 on our agenda this evening will be considered by the full County Commissioner on September 1st, 5:30 p.m. in this room. After we hold a public meeting, unless an application is tabled or withdrawn, the Board of County Commissioners will hold. Then those opposed can come forward. Finally, the applicant may have an opportunity to give a rebuttal to what is said. When the chairman or when the chair recognizes you, please come to the podium and clearly state your name and address before giving your comments. This is not a forum for public outcry or speaking from the audience. You must be recognized by the chair before addressing the commission. If a person's conduct is out of order, the chair may give the person a warning. If the person continues to conduct, or if conduct is extremely out of order, the person may be directed to leave immediately. The first item on our agenda this evening is approval of the July 14th, 2020 Planning Commission meeting minutes. May I have a motion?
So move.
Second.
Is there any discussion? All in favor of approval of the minutes of the meeting, please say by saying yay.
Aye.
Okay. First, the next item on the agenda is CUP 20-7, land reclamation and drainage improvements not associated with a building permit at 3946 Douglas Room. It's my understanding that the applicant has still more work to do, so I would accept a movement to table this.
So moved.
Is there a second?
I second it.
Is there any discussion? All in favor of tabling CUP 20-7, please signify by saying yea.
Aye.
Motion tabled. Next item on the agenda is Variance C 20-2, a request to reduce the minimum lot size in the urban agricultural district to 8.96 acres to correct the easement and right-of-way for Enberg Road. Entertain now a report from Jason.
Mr. Chairman, Commissioners, yes, VC 20-2, it's a variance to the minimum lot size in the urban agricultural district, an application by Ryan Ford on behalf of David and Allison McNulty. Location and zoning, the subject parcel is located at the intersection of Enberg Road and 33 Mile Road. The subject property and all the surrounding properties are zoned urban ag. Here we can see our subject property. We go out on 2026 past Natrona County International Airport. We take the next viable right, which is 33 Mile Road. We go down 33 Mile Road to the intersection of Enberg and 33, and the subject property is there on the west, northwesterly corner of that intersection. As you can see, all the zoning around there is urban agricultural, which is a 10-acre minimum lot size. The McNultys own a 10-acre parcel of land that has been segregated by Enberg Road. As it is constructed, Enberg Road lies further north than it was originally intended, effectively removing approximately 1.04 acres from the main parcel. The McNultys would like to sell the 1.04 acres to the adjacent property owner, the Biggs, and grant a new right-of-way easement to Natrona County for Enberg Road. So you can see here on the map you have Enberg Road heading, and right before it gets to 33 Mile Road, it kind of jogs to the north there. So here's an aerial view. You can see the true property line that runs down through the building and then over to 33 Mile Road. So the proposal is to then effectively carve that acreage out of the 10 acre and then add it to the southern property of Biggs. This is looking down Imberg Road. This is from 33 looking to the west. This is looking from the west to the east. You can see the road jogs there as we get closer to, again, once we get closer to 33. As you see in your packet, we have criteria for a variance. When acting upon a variance, the board shall be guided by the intent and purposes as well as the goals and policies of the zoning resolution. In addition, the board will show showings concerning all of the 7 of the following. We all have packets here if anyone has any specific questions, but I'm going to go through the staff's proposing findings of fact on each item. One, the staff's proposed finding of fact. The location of Imberg Road does create a hardship, creating a separation of the already awkward parcel shape. The 1.04 acres is to the south of the constructed road and could not be developed with current setbacks in the urban agricultural district. Granting the variance would allow the Biggs to incorporate the 1.04 acre parcel into their land. 2, the road was constructed outside the parameters of the right-of-way. This is a unique circumstance for the landowners. 3, the variance for minimum lot size, not the use. No other use would be authorized by this variance. 4, there'll be a positive gain in use for the applicant and the adjacent landowner, allowing them to use their land as other landowners in the vicinity have. There will be no gain of service or income. 5, several hardships would be alleviated. The 1.04 acre parcel could be sold to Biggs. Imberg Road would then be within its own right-of-way, and the Minoltis can start to use their property with an accurate property line. 6, the variance would not impair the use of adjacent properties or the character of the neighborhood. 7, the approval of this variance would not have an effect to the public health, safety, or welfare of the public. The variance will benefit Imberg Road by bringing it into conformity with the new right-of-way that would be granted. So again, that Imberg Road being constructed outside of its right-of-ways is really what brought us to where we are today. The road, for whatever reason, was constructed to the north. It could have been poor soil conditions. We really don't know. It just was constructed outside of its right-of-way. So it created this 1 acre sliver in there. So the request for the variance is then we would have a less than a 10 acre lot, the McNulty property, and then the Biggs would incorporate that into their property.
Mr. Chairman?
Yes.
Jason, was that road supposed to be on the section line? Is that where it would run right through the
It
building?
would have went, if it was constructed correctly, would have went through the building, yes. Public comment to date, Natrona County Development Department has received no comments on this agenda item. Staff sent out public notices to 4 adjacent neighbors. Proposed motion, staff would recommend a motion and vote by the Planning Commission to recommend approval of this agenda item by the Board of County Commissioners with the following condition. Upon completion of the 1.04 acre sale, the Biggs shall merge the 1.04 parcel into their existing parcel. So the intent is we don't want to create a 1 acre lot that would be a problem down the road. That needs to be incorporated into the larger parcel to the south. Staff also recommends all findings of fact set forth in the staff report in this public hearing are incorporated into the motion. With that, I'd answer any questions the commission may have.
Hal?
Jason, there's a ton of background information here, legal and whatnot. What do you know, or what does staff know? This is not the first time this has been a legal issue, correct?
It was a legal issue that brought this about when it was discovered that that building actually resided half on one property and half on another property. The building was permitted legal. It showed a setback off of Imberg Road of 25 feet, but in fact, when that building was built, they measured 25 feet off Imberg Road, not off the property line, thus creating the situation where the building was built on the property line.
Okay. I guess I had the impression from reading through the report that there were past legal dealings here, and I was just curious why they waited until now to get resolved.
Well, and we have the applicants here, but they did go through a civil process with the courts, and this agreement had been penciled out between the two parties. Natrona County was involved in those conversations, and we were all agreeable. However, we do need to have a variance in place to have a lot size that's less than 10 acres.
Okay, thank you.
Any other questions?
Mr. Chairman, what's the county going to do with their easement that runs through the building? Are they going to give it up? They
We-
probably should.
Yeah, we would have no need for the easement going through
Right,
the
but they're
building.
still going to have an easement there when they get done. Even if they get a new easement that goes around it, they're going to still have the old easement. So there should be something that the county should do to give that up so that we don't have a county road running down the middle. Although there is an old lawsuit out in that country that says the county road is where the county road is. So this is a property line
Okay.
issue, but, yeah, they're going to have an easement for the road right through the middle of their building. So the county should probably give that easement up for that particular portion of the road.
Any other questions for Jason? Thank you. Those wishing to speak in favor of the application, please come forward. Anyone wishing to speak in favor of the application, please come forward. Your name and address, please.
Thank you. My name is Keith Nakbar, attorney at law, 123 West First Street, Suite 205, Casper, Wyoming. Members of the commission, I represent the co-applicants, Dan and Ann Biggs, and I am here to, on their behalf, ask for recommended approval of the request for a variance. It was the civil case, in fact, as Commissioner Hutchison said, that led to the discovery of the road issue. But the civil matter has been resolved pending resolution of this by the road issue by the county commissioners. The conveyance that is proposed that necessitates the variance will make of record that which seems to be the case on the ground out at the site, out at the subject property. As Mr. Gutierrez explained, Engberg Road is not in its record platted location. It is actually encroaching on the McNulty's land, which is the applicant. This problem creates a fractured parcel for McNulty's and a parcel of 1.04 acres between the Biggs property, my client's property, and Engberg Road. Someone out there looking at the site would never realize that that was the situation unless they did some research in the land records. And so this proposed variance and the proposed conveyance that would result will not really result in any change out on the subject property. It's simply correcting the records to reflect what actually looks to be the case at the subject property. Resolution of this situation through approval of the variance does three things. It eliminates the need for the county to actually physically move the road if that became a demand, because this will result in vacation of the easement that is going through the building and granting of a new easement at the actual location of Engberg Road where it physically is located. It would eliminate the severed parcel for the McNulty's, and it would eliminate the strip of land that is owned by the McNulty's that runs between the Biggs property line and Engberg Road. It actually makes it conducive, more conducive for both parties to maximize the maintenance and to benefit and productively use their land. As I said, nothing will change on site. Neighbors driving by would not know any different, so they won't see any change in the use of the land. They won't see any change in any of the road or any other construction or improvement on the land. So with that, I'd be glad to answer any questions. We would ask, on behalf of Dan and Ann Biggs, that the Planning Commission recommend approval of the variance as recommended by staff. Thank you.
Any questions for Mr. Nachbar?
No question. Do you know, when was that barn built? The one that's straddling the property line?
I'm going to have to rely on my clients. It escapes me at the moment. 2011. Thank you. So it has existed at that location for quite some time.
And there was a building permit?
I believe
for
so,
that?
yes.
So somebody just missed that?
The belief was that the property line was at Engberg Road, because if you look at the maps of Engberg Road straddles the property line until it gets about, I think it's 660 feet from 33 Mile Road, and then Engberg Road is supposed to go north, just on the north side of the property line. So when the building was built, they measured from Engberg Road down, not realizing that Engberg Road made that job.
Thank you.
Mr. Chairman, Hal, it's my understanding there was an old building there that they tore down and rebuilt in basically the same spot out there. So there was some history behind that location. Mr. Nachbar, you indicated that there was a vacation of the easement. Has that been part of your discussions with the county?
Mr. Chairman and Commissioner Bailey, yes, it has not been vacated yet, but the plan is, as we march forward in this process, the plan would be to basically do an exchange, that the county will vacate the old easement along the section line and be granted a new easement where the road actually exists.
But that's been part of your discussion?
It
to get
has,
rid of
yes.
that? Okay.
Thank
So
you.
we're going to get rid of that easement under their building?
That is correct. That's the
Okay.
plan. Thank you. Thank you.
Any other questions? Thank you.
Thank you.
One more time, those wishing to speak in favor of the application, please come forward. If not, those wishing to speak in opposition to the application, please come forward. Now, I got to do this 3 times. Those wishing to speak in opposition, please come forward. Those wishing to speak in opposition, please come forward. If not, I'll entertain a motion.
Mr. Chairman, I would move approval of BC 20-2, subject to the statements of fact provided by staff, and also including the requirement Mr. Bailey brought up, that there needed to be a vacation of the current road easement that's not being used.
Is there a second?
Second.
Is there any discussion? Those in favor of the motion, please signify by saying aye.
Aye.
Those opposed? So moved.
Mr. Chairman, did that recommendation include the requirement that upon completion of this, the big shall merge that 1 acre parcel into their existing parcel?
I'm assuming that encompassed finding of fact, or does that need to be
Thank you.
stated?
Nope, just,
If you want it in
It's-
there, we'll get it in there.
it's cleared up right now in the notes, so
Okay.
just double
That's my
checking.
intent.
Thank you.
Next item on the agenda is a request to add regulations for utility-scale solar energy system to the 2000 zoning resolution as Chapter 7, Section 21. Jason?
Mr. Chairman, Commissioners, through emergency rulemaking, Board of County Commissioners adopted emergency rules for solar installation of large utility-scale solar installations. Those emergency regulations are set to expire, and so it's time that we move forward with permanent rule adoption. So Good, bad, or otherwise, we do have some experience with the current rules in place, and we had some lessons learned through that process, and we've incorporated some of those lessons in this proposed rule here. The current zoning resolution does not contain specific regulations for utility-scale solar energy systems. With the construction and electrical requirements for safety purposes, the staff in Trona County Development would like to implement these regulations to allow for the option to choose a cleaner, renewable, and non-polluting energy source. On January 7th, 2020, the Board of County Commissioners approved Resolution 0120 implementing emergency regulations as it relates to utility-scale solar systems. The emergency regulations were extended and are now set to expire September 3rd, 2020. So under the current timeline, these will be in place before the expiration of the emergency rules, and we will have a continuity of rules throughout the process. I would add that after Dino Solar, we have had other companies interested in applying for a utility-scale solar, so that's very much going to be a part of our work here at Natrona County Development. The board recently approved an application for Dino Solar for utility-scale solar systems on a parcel of land north of town. During the application, staff worked actively to review the emergency regulations and how they were applied, what worked and what didn't work. One major finding was the setback from residential districts did not work. There was also legislative changes that became effective July 1st, 2020. Most of the additional requirements are from incorporating these regulations into the amendment. Proposal incorporating the utility scale solar systems as Chapter 7, Section 21 of the zoning resolutions. Changes include requiring evidence of compliance with any applicable FAA, FCC, industrial siting rules and regulations. Here's the key: when reducing the setbacks from 1.25 mile setback from a residential zoning district to 500 feet. We found that the 1.25 was the most restrictive example we could find in the United States. In the end, it was 500 feet was a agreed upon setback. Add a setback of 150 feet from an existing residence not within a zoning district.
Jason, can you entertain questions?
Certainly.
That last one kind of intrigued me. I didn't quite see the rationale for me. And that is, if you are within a, say, a subdivision, housing development, you get a 500-foot buffer. But if you were in Ram, say, and you happen to have a ranch house just across the road from a solar development, that single house is only getting 150 feet. It's still a resident. I don't see the need to single that out. Why not 500 feet from any resident?
That's certainly an amendment that the board could consider. I believe the rationale with that is you have a residential district, so that is a zoning where we're talking about many homes. And you're right, the 150 is just an existing residence that's already there, not in a residential zoning district. They're in a, like you would propose, a RAM or an urban ag. That's certainly an amendment we can change if that's the board's pleasure.
Mr. Chairman, another question for Mr. Gutierrez. Are these 500 foot and then 150 foot, are those, do those come in any way from the state of Wyoming's legislative deals that went into effect 1st of July from this past session?
I turn to Trish, as she's been ingrained in this more than me.
The current legislative changes that were done actually allow counties to reduce the setbacks to their current zoning districts. So in this instance, we're well above what the state allows us to be at.
Okay.
Does that answer your question?
So it lets the counties do what they want to do individually? Okay. Thank you.
We could go down to as little as 10 feet.
Right now ours is 25 and 25 and 10, and the state would allow that.
Okay, thank you.
Changes continue to require the applicant to provide notice in writing to all landowners within 1 mile and cities and towns within 20 miles of the application. Legal access requirements, public hearing requirements, and the addition of fees. I know a few of you have called Trish and worked through some proposed amendments, some verbiage throughout, and on each of your tables there, Trish has handed out a kind of a summary sheet of all the proposed revisions. So with that, we don't have any public comment on this proposed rule set, so I would offer we can start going through those proposed amendments at the chairman's pleasure through that list and go that direction.
So reference was made earlier that Charmaine and the legal staff had been involved. Is this reviewed for them, or are we making comment tonight and then Charmaine's going to take it from there?
It has been sent to legal.
So is this a result of what legal's provided, or is it still in the bin?
Oh, that is the result of what's
Okay.
sent to legal.
Thank you.
Mr. Chairman, I think the only, really, if you look at it, the only part of this is section 21G10. It says add bond, shall name Natrona County as beneficiary, or other languages approved by legal department. That's about the only one, I think, on this list of changes that's really needs maybe a look at by legal. The rest of them are kind of verbiage and changing things. And then if you wanted to look at the 150-foot setback, the rest of them are here, and we've gone over them, and they're, in my book, they're minor changes, verbiage, and a couple of corrections to legal, and probably a correction to spell check.
Got a comment, and I think I brought this up. Under 21A, I still think we need to specify that we're talking about a photovoltaic installation. We're leaving it open or other solar conversion technology. And the reason I brought this up, because there was a clause in the original proposal that limited heights to 25 feet. Now, if you went to the kind of facility that uses not mirrors, or rather not photovoltaics, but mirrors, then of course those towers can be up to 800 feet. So you do say, I would just like to specify photovoltaics in this case. These are passive and not the mirror arrays. I'd like to be absolutely clear that we're not talking about mirror arrays, because if we leave ourselves open to encompassing those, well, it's a whole new ballgame when you're, calculating glare angles and reflections to pilots. So that would be my comment. Let's limit it to photovoltaic solar farms.
Mr. Chairman, Jim, would that take out, the first one she does is takes out concentrating solar power,
Right.
CSPs.
Yeah.
Is that what you're talking about?
Yes, that's the tower.
So
and mirrors.
if we pass these changes, that takes care of your concern.
Well, no, by photovoltaics or other solar conversion technology still leaves it open to a CSP. We've eliminated reference to that, but we're still implying that someone could come forward with a concentrating system. So I would strike
I would
or
think
other
we'd want to
solar
look, I
conversion.
think we'd want to look at an 800-foot mirror.
No,
and say-
tower.
Or a tower,
Yeah.
then that says, hey, it's not in here, we're gonna play with it differently.
Yeah.
Mr.
But
Chairman?
unless you say other solar conversion technology covers that, I suppose we could strike or other solar conversion technology.
That's what I'd be comfortable
And
with.
continue
so.
to strike. Okay.
Al?
So if we struck or other solar conversion technology.
That would be my recommendation.
I understand there are basically two technologies. One is the farm and the other is the the concentrator, and that's what we're talking about
Right.
here, right? What has the state done? Has the state looked at both? As far as their rulemaking, as far as the new legislation?
I have not seen anything in regards to the concentrated solar power. Every reference I've seen is to the panels themselves and the photovoltaic.
I know during the Dino Solar, a lot of the concerns we were getting were with the concentrators. And once the folks realized it wasn't a concentrators, their mind was at ease. And it appears that industry-wise, the concentrators are not being further developed. They're being decommissioned and
Oh, yeah,
taken out of service.
interesting.
Excuse me, Mr. Chair. I believe it was County Attorney Eric Nelson that worked on this, so that's a question that we can follow up with him.
Mr. Chairman, my concern would be is if we leave it out, are we just letting it go wild on that side? Or if it's not here, do they not have to follow anything and they can go just do what they want?
Well, I think if someone came forward with a farm concentrating solar power to a tower, atop which is some kind of tank with fluid that boils to steam, and that's a whole different breed of cat here. I mean, the
Well, I
regular,
just don't want to leave that hole.
yeah.
You know, if we take it out of here, then it's gone from any regulation here. Does that mean there's no regulation of it at all?
I would recommend that a separate set of regulations would have to be addressed for a concentration system because they're
We
so
might hope
different.
so.
Yeah.
Mr. Chairman, one other question. So, Jason, I note on section 21, this is AC, having to do with site management. Be on the second page, top of the second page. Dust control within all phases of the project is mandatory by means acceptable by Natrona County and WDEQ. As we talked earlier, when Dino Solar came here, I think there needs to be something a little bit more explicit that requires the applicant to obtain a bond.
The bond
Actually say
spec-
that instead of just having them say, we're going to give you a
Yeah.
plan, and then the plan never works.
Yeah. A bond specifically listed to
Trish,
wind
where's our
erosion.
bonding?
Yes.
Yeah.
I know it's in here. We have a bonding clause that's coming into this.
Decommissioning.
Yeah, that's in decommissioning, okay. We could almost bond every piece of this thing, though. That's the problem. If they start kicking up dust, we've got to say, hey, you've got to meet the Natrona County and WDEQ regs. And if they don't, you could stop them. Better than a bond.
Invariably, you've got
get their
damage
attention.
downwind, Mr. Chairman. Invariably, you got damage downwind to homes and whatnot. And instead of going through the hoops, if you've got that bond, you just say, do it, apply it to the bond. We've had experience with that with the city of Casper, and it's incredible the damage can be done with dirt around here.
Staff would also support that, and I have had experience in similar fashion where folks strip off a subdivision, so to speak, and I granted that's in town, and a lot of these aren't in town, but Casper's climate is such that, man, we just get a dry spell and some wind, and it's simply uncontrollable at that point.
Not if you put water on it.
If you
Full
if you can
time,
keep it up, yeah.
24 hours a day.
Yeah.
If I can speak to the setbacks, I alluded to it in your presentation,
Yes.
and this is section E, setbacks. Again, I question singling out a single residence that doesn't happen to be in a zoned residential area being discriminated against in terms of setbacks. It would seem to me if you're going to set back from homes in a duly zoned residential area, that should also apply to homes that are not in a duly designated residential area. I'd like to see it residence or some accommodation to that single house that's going to be out there in the middle of nowhere, 125 feet from an installation.
And can I comment on why that's in there? Kind of give a history of the
Sure.
125 feet was put into a lot of the regulations that I researched to accommodate the landowner as one. So if Dyna Solar and Voorhees had a home on their land that they were leasing out to a company, they have to meet that same 500 if that's the case. But this would be on their own land in the RAM zoning district. So they did reduce it for residences on the same parcel down to 125 feet. The other one is for homes that are in light industrial or homes that are in commercial zoning districts. So they're not residential districts, they're in business districts, so they shouldn't be 500 feet from that district when they're already in a commercially zoned district. So that's where that came from, is to accommodate the other zoning districts that wouldn't allow homes typically.
I would suggest that language be made explicit in the regulations, so we're knowing the reason for that.
To same water tract as the farm, or?
Yeah, I think that needs to be expanded. I didn't realize
You
that
still-
was the intent.
With that logic, though, you're still sweeping in houses that are out there by themselves, and you're not giving them those 500 feet. I mean, let's say I'm living out there, and I've got 10 or 20 acres, whatever I need, and I've built close enough, and no matter, I mean, you could go to define this like crazy, and I'm still swept under the 500-foot or the 125-foot piece, no matter how you define the commercially zoned, the other zoning districts that houses maybe shouldn't be in that are, and I get swept up in the 125 foot when I'm just sort of out there. So I don't know how you're going to balance, how you're going to say, okay, it's 125 feet for all of these, and then a single residence we want to take to a 500 to match the zoning areas. I mean, that's going to be a tough.
Well, and these regulations would apply specifically to the zoning district. So where we have residential, it would be mountain residential, suburban residential, rural residential. Those are the residential districts, your RAM, your urban ag, light agriculture, commercial, heavy industrial, non-residential zoning districts. So that 125 would apply to those ones, not your main residential based zoning districts.
Yeah, we have to see how it comes out, because if the language isn't just right, you're going to sweep some of these people one way or the other in this deal.
Entirely at the board's discretion, we can go either way.
So let's talk about this single, like you were talking about, Bob, it's single.
One guy
So
out there.
generally, if you're single, and you're probably either an RAM or urban ag, correct?
Yeah?
So generally, those people are probably going to be involved in the lease of the land, I would assume. In most cases, is that not correct?
Well, it would be up to the scope of the development and
You
the
could miss a
program.
tract out on the edge.
Right.
If it's in the middle where you want to be, no. Yeah, no, but you could miss somebody on an edge.
I mean, I think the assumption is that person who may be 125 feet away from the development has already leased the land to the developer and is particularly comfortable with that because getting some kind of financial gain.
Maybe not.
But exactly, maybe not. That's an
And when
assumption.
you throw the maybe nots in there, then you've
Yeah.
got these issues of
So
words, or
couldn't
what
we
they're going to
take
say.
and word it in such a way, if you're not getting any financial reward, that then the setback changes? That's one way to cover that.
That's one way to cover it, yeah. Then they could come in and buy you off and pay you, and then you could be 125 feet away, and I
That's
got paid
correct.
for it, and there's consideration, and away you go.
There, it's correct.
And that's always the case. If you're getting some benefit from any kind of commercial development, then you're likely more accommodating. But I just didn't want to penalize somebody that's not within the leased land and not in a residential area, but still is out there and, again, has only one-fourth the setback of the other people. I think that has to be addressed.
Okay.
Mr. Chairman, I got a couple other things. So, I've had some familiarity with these solar farm issues. So I understand the state is still pending on whether you have to go through the state to get an industrial site permit? Are you,
I believe industrial siting has to do with the size or the total dollar number associated with the project, and then it'll get sent to industrial siting. That doesn't preclude, I don't think, us from going through our process, but then additionally, they would have to go through industrial siting.
so it's first or second, or what are we?
I believe we're first in the process.
So the state can come back and say, no, you need this in addition, or?
Correct me if I,
I'm not.
Or-
Talking about
Or what if the state says you need something, or if Natrona County says you need something and the state says, no, you don't?
I think the intent with the state language was that the county would have a say in it, so I would say we were first. There was a move at the legislature to send all solar panel siting, solar installations to industrial siting, and that failed.
Oh, okay.
And so it was in fact set up where the county would have some say in it, so I believe we would be first in the process. The state would defer back and say, what does the county have to say on this?
Okay,
We can surely check into that to make sure I'm not
okay.
off base, but that was, I remember that was a conversation during the legislative session, as they were gonna have total control, and that failed, and
Okay. And the second question I have is, didn't see addressed, is co-use, ag co-use or whatever, junkyard, whatever. Do you think that needs to be addressed in here somehow?
I'm not sure I'm exactly following.
So it's set up and we're gonna have a conditional use permit or something, I guess? And if they wanna graze cattle in between the panels, or if they wanna have a junkyard, or how does that work?
Well, a junkyard would be another conditional use permit in most zoning districts, so that one may be an outlier, but if they want to graze cattle, that's a permitted use. In fact, I think Dynasolar pointed out in one of their slides there, they showed sheep going through the solar installation.
Okay,
So, historical allowed uses would still be allowed. Anything like a salvage yard or a junkyard that is a conditional would still be in another conditional use permit beyond that.
so they would have to get specific authorization to do whatever, in addition to the solar.
Go back to the permitted and conditional uses within that zoning district and follow them.
Okay,
I would guess that would probably be addressed in the lease between the solar and the rancher, to the extent of grazing and that type of stuff, because we have fence requirements,
Mhm.
which are gonna exclude a lot of that other stuff.
hopefully, hopefully what the landowner has in mind is gonna fit what,
When my
The
concern
county
is
is-
decommissioning, when we have a bond, which is gonna come in here, and Natrona County's not on the bond, and the rancher takes the bond money and leaves it there.
I think I saw somewhere in here that the county was supposed to be an additional insurer.
Well, we added that in.
Who is we?
Tricia and I, for your approval.
The way it was previously set up in the document was we had that follow decommissioning per a wind application. And in the wind application, it says the bonding has to be set up to the Board of County Commissioners' liking initially. So we were always going to have that ability to have Natrona County as an additional, but that's good to put it in black and white too.
Put it in there is probably better.
You know, all in all, the regulations, the emergency regulations went off without any noticeable hitch, with the exception of the setbacks. That 1.25 was a hardship to Dyna Solar, and when we looked around, we found out, yeah, that's a very difficult standard. And so really setbacks were the big thing that we hit utilizing these regulations.
Mr. Chairman, one more question.
Go right
I understand there's a statewide network, I guess, of, there are other counties, not only Natrona, but Platte, I understand, and Sweetwater has had the deal. You guys have talked to Sweetwater, because I understand they've had all kind of issues there, one way or the other, with what they have. Is that reflected in what we see here?
Yeah, so that's where the regulations initially came from, was Sweetwater. And yes, we have had conversations with them, and the Wyoming County Commissioners Association has also speared up an effort to get all the counties talking together, and we're in contact with those folks and would be sharing this with them also.
So this reflects all that
Our
communication?
best known knowledge as of today
Okay.
on solar regulations.
Great, thank you.
Are there any other questions?
Mr. Chairman, just as a note, if we have an issue with something in here, we can fix it.
Absolutely, we can do a text amendment in the
We can
future.
do an
you bet.
amendment on that and say this isn't working, or oops, we forgot it. You know, we got an oopsie here, we need this, and we can come back in and fix these and change it. So,
Well, and I would point out that Natrona County is in the contract stage of a rewrite of our zoning resolution. These emergency rules are scheduled to sunset prior to that rewrite process, but we're gonna have another 18 months where we're looking at the entire zoning resolution, and if we need to revisit one of these, we're gonna have another real close opportunity to do that.
How often do we do that? Go through the zoning resolution?
I'm sorry to
It
have
was
sent us down a
2016
rabbit.
last.
I apologize, we sent us down a rabbit hole. No, our zoning resolution is 2000, so it's an 20-year-old document. You're thinking of the land use plan, the land
Oh,
development
okay,
plan.
all right.
Jason, what do you want from us? You want a motion?
I would
for
like a
approval?
motion to approval with those amendments, and we'll make those revisions as we head it up to the county commissioners.
Then I still have a question about the setbacks. I do think that needs to be amended in some way, shape, or form. And I don't know how to handle it. There's other issues, but in my opinion would be just to eliminate the qualification and just say 500 feet from a residence.
I'd go along with that.
Bob, what do you think?
that's probably the easiest way to go, because you get into the, like I said, you get into the definition stuff, and you start trying to define here and here and here, and we're gonna miss this one over here. So if we say it's 500 foot, that's it. If that's too close, they can come in front of us and say it's too close when we do the next permit, or if it doesn't work, we can come back and change the document. And that probably is,
Well, then they could always come in
Probably
and
easier.
ask for a variance.
sure,
Yep.
sure.
I guess I'd entertain a motion.
Mr. Chairman, I'm looking for it. I know there's a good statement in here that Jason has. I move approval of the proposed addition of Section 21, Natrona County Utility Scale Solar System Regulations. Incorporating by reference the finding of facts set forth herein and made a part hereof, and correcting or changing the sections that Trish held out, 21B2, 21B8, 21C2, 21C4, 21E2, 21G1, 21G7, 21G10, 21G12, 21G15, 21C3 is not on this list. That's the bonding request that we had. 21A that Jim Brown brought up, and 21L, which is the definition. I would like to add G11, correcting the typo mistake so that it's in the record, from and to an, and 21E, is that E2? No.
Setbacks.
Yeah, 21E2, amending that language to read 500 feet from a residence, or something that works along those lines.
Is there a second?
I'll second the motion.
Any discussion? All those in favor, please signify by saying aye.
Aye.
Opposed? So moved. Thank you. The next item on the agenda, Zone Change 20-2, will be heard by the Board of County Commissioners not on September 1st, but on September 15th. That means that any proposal we make about that particular change will be heard by the county commissioner on the 15th. Jason, would you like to address Zone Change 20-2?
Mr. Chairman, Commissioners, yes, ZC 20-2 is a request for zone change, an application by Taylor Cook and Kay Page. Changing the zoning district classification of a 43-acre from ranching, agricultural, mining, RAM to urban ag. Location and zoning, the parcel is located roughly 1/2 mile west of Poison Spider School and south of Poison Spider Road. The parcel is more commonly referred to as 2922 and 2942 Phillips Lane. The subject parcel and the parcels to the north, south, and west are ranching, agricultural, mining. The parcels to the east is urban ag. Again, this is right on that westernly boundary of urban ag and RAM that we have discussed previously, other applications. The highlighted here is the subject property. Again, we are south and west of Poison Spider School. We are west then of 12 Mile and Poison Spider. You can see here we have our subject property surrounded in the red. We have urban ag on the east, RAM on the west. There to the north, if you will, you can see there was a piece of previously RAM that was zone changed. You'll see in the staff report here to urban ag recently. There have been 5 previous applications to rezone parcels in this area. You'll see there's a few there that they didn't proceed to BOCC, one that was denied by planning but then did not proceed to BOCC. There was a zone change request from RAM to SR1 in 2016. This application was withdrawn before Planning Commission, so the applicant withdrew it. And then in 2019, a 20-acre parcel was approved from RAM to urban ag. That would be the northern parcel here. So that one was a 20-acre parcel, was approved to go from RAM to urban ag. This is, we're looking in the area. This is that Pine Ridge Road. That's that the road that would have went down in that green section. This is looking south on Phillips Lane, so just beyond those trees is the subject parcel. This is looking southwest across Phillips Lane. These photos are indicative of what you would see out in that neighborhood. The Planning Commission and the Board shall require that the applicant provide evidence that the proposed zone change will meet at least one of the following criteria. So, you know, in your packet there's 6 criteria for zone change. The applicant is seeking a zone change under criteria 1 and 6. There is a need for smaller lots, particularly in this area because of good municipal water, easy access to Casper, good soils, and in some case irrigation rights. Many homeowners want smaller rural properties for these reasons and choose to live west side of Casper to locate their homes. Demand for small rural properties is strong on the west side of Casper and does not appear that the zoning adequately accommodates that need. Criteria continue. The recent subdivision on 8 Mile is proof of high demand. There's approximately 9 lots that were 12 to 15 acres in size that sold within the first year. Newly installed water main in Phillips Lane will provide water to an additional 65 to 114 homes. So there was a water line that was replaced going down Phillips Lane, going from 0 down to the south. Poison Spider School was recently replaced, and this allows for school district to accommodate for increasing number of students. The zone change will not result in a spot zoning, as the subject property is contiguous with property that is already zoned urban ag. The zone change does conform with our development plan. Again, these are reasons the applicant has provided us for this zone change. Staff's findings. The 2016 development plan for Natrona County was adopted July 5th, 2016. That was one we were looking for here in the last hearing. The recommendations for this area is to have low-density residential development, with the zoning being RAM and urban agricultural. Low density shall be based on a maximum of 1 unit per 5 acres. The subject property is adjacent to land already zoned urban ag and shall not constitute a spot zone. The request does comply with the Trona County Development Plan. Public comment. The development plan notified 14 property owners within 1/2 mile. Adjacent letters were sent out June 29th, 2020. Staff did receive 1 comment this morning in opposition, and I believe Trish included that in your packets, the email on that. With that, I'd answer any questions the commission may have.
Question?
So just, correct me where I'm wrong, Jason, but when we did the 2016 deal,
Mm-hmm.
I remember from day one, the consultant, and perhaps it was, and I'm sure it was with the direction of staff, said, okay, here are the areas around our 5,000 something square mile Natrona County that are issues. And here's one over here, here's one over here, here's one. I've always wondered, what about all these, does the staff keep a map? I mean, this thing's been going on for years here, and there's other places around. I wonder why that wasn't part of the 2016 effort to identify that as a zoning issue that maybe we needed to, as part of that 2016 plan, make that urban ag and take it out of RAM. Or am I doing it backwards? They want urban ag, right? Yes.
The applicant's requesting urban ag.
Yeah.
I mean, we've had, staff has brought this up. I mean, there was a countywide proposed effort to change that line, to move that line further west, and that was met with resistance with the neighbors, and they were not in favor of that. You know, you point back to the hot spots, and if we were to update the 2016 and, I don't know, 2025 maybe, we would identify western properties here as a hot spot, if you will,
Okay.
and get the consultant to help us weigh in on that. But
And I don't mean just to jump on staff for not recognizing this, but the property owner, I mean, that's been in the family for a while. They could have stood up and raised a flag in 2016 and say, take care of this as part of your plan so that we don't have to come in individually and deal with it like you're doing tonight.
And remember too, Natrona County hasn't had a countywide rezoning effort in several decades. Whenever we've changed zoning, it's been with consent of the property owners. The property owners actually come in and sign the application that they are consenting to this zone change. So a little different approach there, where we're not necessarily proposing it. This is the applicant, the property owner, has come forward and is requesting a zone change.
Thank you.
Mr. Chairman, do we know what they're gonna do with this? I was out there and looked, and there's a center pivot irrigation system there, and you wonder why they need to change it. I mean, there's a couple of houses, one's not in it, and one appears to be in it, and it's kind of an oddball shaped piece in there. And are they gonna subdivide it?
You know, the applicant's here, and I know they're gonna come up and speak, and so I'll let them elaborate on that.
I have a question, Jason. You explained now the outlines of the application are for that larger polygon encased. And what's the significance of the smaller polygon? These are two separate owners?
So they were two applicants. Kay Page is one property owner, and
Okay.
Taylor Cook is the other one. So
Those,
I believe they are family members, both of them. And so they both wanted to be together on this.
all right, thank you. Any other questions for Jason? Those speaking in favor of this application, please come forward.
Mr. Chairman and Commissioners, I am Keith Nakbar, attorney at law, 123 West First Street, Suite 205, Casper, Wyoming, 82601. I'm here on behalf of the applicants Kay Page and Taylor Cook, who are a grandmother and grandson. I'm here to ask for approval of the zone change on behalf of the applicants. The parcels involved comprise about 43 acres of land. And really, if you step back and look at the big picture here, we are really asking to make the area zoning comply with the de facto situation in the area, or the reality of the area. There are many lots, as Commissioner Hutchison mentioned, this is a hotspot because there are a number of lots in the area that do not comply with RAM zoning. They were pre-divided before RAM zoning, and they are less than the 35-acre minimum in RAM zoning. That includes the ones that I've identified are Glow, what used to be Weimer, Ghaffari, Tubbs, Milne, Rowe, Robinette, and Carpenter, all in the general area here, with lots that are less than the 35-acre minimum for RAM zoning. The staff noted, and we highlighted in our application, that there's great demand for these smaller 10-acre or so parcels. The subdivision on 8 Mile Road, as we used as an illustration in our application, sold out within, I believe, around a year. There is adequate water supply in the area. The letter that we included with our application from the consulting engineer, I believe it was, says that there is capacity of 114 3/4-inch taps or 65 1-inch taps on this water line that serves this area. The parcel that is the subject of this request is contiguous and adjacent to other property that is UA. If you look at the map, UA is everything to the right and even a parcel to the north, to the east, and a parcel to the north. This area appears to be RAM simply because that's where the line was drawn. I mean, if you look at the reality, if you turn in the packet to the drawing that has all the various parcels, this one here in the staff report, you can see numerous parcels that are less than 35 acres right in this immediate area. And so, as such, most of these parcels don't fit in RAM, but many of them do fit in UA. The development plan for the county that was established in 2016 supports the proposed zone of urban ag because it seeks low-density residential development in this area. That is, in fact, what exists in much of this area around the subject parcel, and it makes sense to adjust the zoning to match the reality of the situation. It seems evident that the landowner, in this case the applicants, should be permitted to use their land to its maximum potential as long as it's consistent with the development plan. And in this case, in order to do so, we would request a zone change from RAM to urban ag. Let me address one of the questions that was raised earlier regarding these two parcels. So the smaller parcel belongs to Taylor Cook. The larger parcel belongs to Kay Page, their grandmother and a grandson. And that parcel, the smaller parcel, was segregated off in approximately, I'm not 100% sure on the date, but around 2012, based on a belief and information that was provided, I guess, by Gene Wallace, that left the owner to believe that a family exemption would allow that parcel to be carved off. Currently, the department staff does not subscribe to the same analysis of the family exemption requirements. And so the family exemption, according to staff, does not allow that parcel to be carved off the way it was. And so in order to come into compliance with the zoning, we need to try to change this zoning to urban ag. So we would ask you to approve or to recommend approval of the zone change from RAM to urban ag for the approximately 43 acres that's outlined. Thank you, and I'd be glad to answer any questions.
Any questions for Mr. Nakbar? If not, thank you.
Mr. Chairman.
Oh, go ahead.
Your clients, are they going to subdivide this land?
I don't know one way or the other. I don't have specific plans. I don't know that they have specific plans. Obviously, a zone change would allow subdividing,
Right.
going through the proper process of
Understand.
subdividing, obviously. So I don't want to say, Mr. Bailey or Commissioner Bailey, no, that's out the window or out of question. It is a possibility, but there is not a plan at this point that I'm aware of. Thank you.
Mr. Nagbar, isn't the family exemption statutorily set? How can this county vary from what the statute allows?
Well, you raise a kind of a hot topic, and that is, does the family exemption that's carved out in statute override the county's zoning requirements? So in other words, if you fall into the family exemption, do you still have to apply, or do you still have to comply with the zoning requirements of the county? It's my belief, and I'm just one person with an opinion, it's my belief that the family exemption should or does override the county's zoning requirements, because otherwise, the zoning requirements really make the family exemption useless.
Right.
And so, but I know that the staff's position at varying times has been the opposite.
Well, I know that Barry Williams told me one time, because I was an attorney, I didn't get an opinion, so I have no opinion on that. But I always had felt that. That's a statute. Do you know, by chance, and you referenced in your letter, the subdivision on 8 Mile Road?
Do I know the name of the
No.
subdivision? Oh.
You reference that in your letter. Do you know how far that is away from here?
I do not know.
I do. I was out there and drove it. It's not a comparable, I would not compare that to this. It's well over 5 miles away, over 2 ridges, and quite a ways away. So I'm not buying your that close, because when you drive out here, there's nothing in the UA zone from there almost to the road to Bessemer Bend. This is the only group that's right there, and there's nothing very much to the west and north of that. So whether you're trying to fool us with this thing or not know that I go out, and I know how far it is, because I drove it, because I read your letter and I drove it and let you know, but that's not close,
Okay.
okay? That's just a comment for you, that we do read these and look at these projects.
Thank you. Mr. Chairman and Commissioner Bailey, I think that the point of bringing that other development up is not so much the proximity as it is, it's in the area and it demonstrates demand. Now, whether your definition of in the area and my definition of in the area might be different.
I think they're different.
It is in that general area of Natrona County. I think we can agree on that. It may not be.
West Natrona County.
Right.
It's an area.
Right.
Right.
Mr. Chairman, I think I would give the gentleman credit for representing his client.
I don't, because they always do.
And as he should.
That's part of your job, I believe.
So my point is he shouldn't be put down for that.
Any other
Not a
questions?
put down.
Any other
You
questions?
just gotta know that I go out there and I said, look, if this is close, I drove it and I punched in the trip odometer and drove it. So I know how far it is.
And so do I. I went out there. And
It's
yes,
not
I
in
knew
that
where-
area.
I knew where it was.
Any other questions? Thank you.
Thank you.
Anyone else wishing to speak in favor of this application?
If I can just add, my name's Jerry Cook, I live at 2850 Phillips Lane. And I just would like to add that the reason we put that on there for the 8 Mile property was that was a subdivision that I had sold. I was directly involved in that, or somewhat directly involved with that. I sold the property to Lisa Burridge, and we ended up, subdividing that parcel. And so that was the reason. It was fresh in our mind, and that's why it was brought up. And as far as your question, or I can't remember which one of you asked about the subdividing of this parcel. My son is Taylor Cook, and he wants to basically buy more of the property that my mother holds, who is Kay Page. So yeah, we would look, I don't know that it would be a subdivision as much as it would be a lot split of some kind, but that would ultimately be our goal, or his goal.
But not much further than a split into two.
Just the
You're not
same
get-
two people.
Yeah.
Same two people that own it, it just changed hands as far as the amount.
So Jerry, I take it you're speaking in favor of the application?
Yes, sir, I am.
Just wanted to make that a
Guess I
record.
should get that on record.
Question for Mr. Cook. So
Go ahead.
you mentioned 2850?
Yes, sir.
Can you, where is that?
It's the large piece there, the center pit that you see is mine.
So where is 2950, the Lees?
They are UA, right there, the 40-acre parcel in UA,
Okay.
so.
Any other questions for Mr. Cook? Thank you.
Thanks.
Anyone else wishing to speak in favor of this application? Those who wish to speak in opposition to this application, please come forward.
Okay.
Yeah.
I'm Harv Glow.
Excuse me?
My name is Harv Glow. I live on the adjacent property just to the north of the subject properties. And I've lived out there 40 years, and so I've got a little bit of history on the place. And, this reason there are smaller tracts there, it wasn't an Irvine property, and it wasn't rural ag and mining until 1983. That's when the zoning was changed out there to protect the ag industry and the people that farmed out there, I believe. And at that time, there was, the 3 or 4 properties there, smaller than the 35 acres, so. And, it's always been rural, and we'd like to see it stay that way. So I'm here because we got this notice, and it was kind of short on who, what, where, when, and how. So there's other neighbors that are curious too, and I kind of got elected to come forward and see what I could find out. And some of the questions are being answered already. But I guess one of the things that, are concerned about is this thing is getting chopped up out there into smaller and smaller pieces. The new urban ag part that's just to my north was RAM until last year. And that map is kind of deceiving. The urban ag to the east of that is a state school section and will never be developed, hopefully. So, that
excuse me.
contingency.
What's the south boundary of that state school section?
Excuse me?
I'm wondering what the south boundary is. Is it shown on that map? That's the south boundary of the state section?
Yes, that's right.
Okay, thank you.
So it's not entirely what it seems there, so. And as you saw in the lead into this thing has been proposed several times and denied several times, and we're just wondering, what has changed to want to make it forward? I mean, when this property was bought, it was rural ag and mining, that whole section 17. And Cook came in there and put those parcels in there without getting permission. He disregarded the zoning and requirements and put those in there anyway. And there's also a third property just to the west of those. It's a 5-acre tract. So this is getting chopped up here pretty regular. And, the neighbors around here are a little concerned about it. So, I mean, it doesn't show just a little gray line on the map here, but there is a 5-acre tract right there in that cutout part. I don't know why is that not being addressed for a reason?
Where exactly is that? Is it anywhere on this map?
Yeah, upper left corner of the red.
Right at where Phillips Lane makes a hard right to the east.
Uh-huh.
Okay.
So it's that little triangular portion?
I don't know.
That's correct.
Oh, that's there.
And that property is owned by Dana Bowe.
Can I ask you, how long has she been there?
Excuse me?
How long has she been there?
It's a he.
Or a he, okay.
And, they just moved in the last fall, maybe? Not
So-
too long ago. They haven't been out there maybe a year.
And that's always been 5 acres?
No, it was originally part of the Phillips Ranch. And then it was bought by Munzell. And then when Munzell sold to Cook, they carved that little 5-acre tract out, I believe. I'm not sure of the time frame on all this stuff, but it was cut out. And that's one of the questions we've had out there is, who is watching this? Who is responsible for keeping the integrity of the zoning, out there? We've gone through this, as you've seen, this thing has been proposed for change several times. So that's kind of why we're a little concerned about all this. There's currently 3 young families with children living out there also. So it's not like it's, devoid of people, and meeting the criteria for the county's development plan. So anyway, that's, just keeps chopping up, and it's getting kind of, disturbing. What does the county do? I mean, right there in your mission statement, it says you're to protect and enhance the quality of life for present and future inhabitants of Natrona County. Well, we feel like our quality of life is being impacted by this area being cut up.
Mr. Chairman, is it Mr. Glow? What's your last, I didn't catch your last name.
Glow, Gloe. I'm sorry, I'm a little hard
Glow,
hearing.
okay. How much land land holdings do you have in that area then?
I have the 20 acres just to the north there of the property.
Okay, between the urban ag, 20 acres, you're between the two areas.
I'm
You're the guy,
so-
but
Yes.
you're between the urban ag section and this what we're talking about.
Right there. I'm right where the, Phillips Road comes down from Poison Spider Road.
You're on the
Takes
east
a
side.
hard right, I'm on that corner there.
Okay, thank you.
And I've been there for 40 years, so there's been a few changes out there, but, it's getting accelerated.
So you were grandfathered less than the 35 acres?
Right,
Okay,
yeah. Yeah, I guess I didn't make that point, but yes.
okay.
Any questions for Mr. Glow? If not, thank you.
Okay, well, and something else that kind of disturbs us, that Phillips Lane is a private road. If we put more and more houses back there, is the county going to start taking care of that as a, for, maintenance and fire protection and, coverage like that?
Well, I'm afraid we can't answer that question, but it does pop up
I can't.
frequently.
No.
So, Mr. Chairman, so if this were to, if this were to be approved, I notice there's a preliminary plat in the, we would anticipate a subdivision to result from this, right?
The zone change would be able to allow Taylor Cook to grab some acreage from his grandmother and incorporate it into his own. So there's not going to be a subdivision, there's going to be a boundary line adjustment between the two current property owners.
Okay, so that doesn't have to be a subdivision,
Correct.
a lot split, basically.
It's an exemption from subdivision regulations, so it's a deed.
Okay. So there would be no subdivision requirement that a, what do you call it? The Improvement and Service District be formed?
No.
Okay.
But does that preclude the formation of a service and improvement district? It'd be up to adjacent landowners. Thank you. Arv, do you have anything more?
Well, just for clarification purposes, I guess, I want to make sure I understood that right. You're not going to be subdividing this any further? It's just for a boundary adjustment between the grandson and his grandmother to do what?
So the grandson is going to incorporate some of the grandmother's acreage into his existing lot at this time. In the future, I don't know, but as of right now, the plan is to take Taylor Cook's acreage and expand it by a couple acres.
Well, it's still in violation of the zoning requirements of a minimum of 35 acres.
But if the zone change to urban ag is approved, it would be 10 acres.
Okay, well, you got 3 properties there, the Bow property, the Taylor property, and the Page property, so it's approximately 50 acres, where the minimum is 35, so right now. And so that's why, our concern is how these things are being chewed up a little bit at a time. How many, bites at the apple do you get? So, anyway, thank you for your time.
Thank you. Anyone else wishing to speak in opposition to this application? Anyone else wishing to speak in opposition to this application? If not,
Mr. Chairman,
I'd attend. Can we discuss?
could we
it?
have the applicant show us how this split's going to be? If you're aware?
I'm really not. I think it's gonna be. Can I?
Yeah, come up. See, I've got that.
Okay.
Okay.
So I believe they're looking to split this to where this entire parcel right here would become Taylor Cook's.
So you'll come straight down this line?
I believe
Well, see
so.
now, I wonder why this is here in yellow, because his is up
Well,
here.
this will be in addition to it. So this was a parcel that was owned by Kay Page.
this
And this
piece,
will encompass the whole property, yeah.
all of this was owned by her, and she gave this.
Right.
And then she's gonna give this, and you're gonna give this.
Well, we own everything over this way. And so basically, it'll be K-Page that will be splitting this lot.
Oh,
Down.
she's gonna be over here.
Correct.
And if that line comes straight down, then you're gonna own this clear over here.
Well, Taylor
Well,
will own this.
Yeah,
Yeah.
oh, clear all of this over to here.
That's correct.
Okay, okay.
Could I see that?
It's just a straight line down.
Yeah, basic.
Okay, so that straight line leads down.
So it'd be 20,
This right here would be Taylor Cook. And this one would be
approximately.
So it looks
half.
like 20 and 20, and
This
then
comes straight down.
this side
So that's Page.
is gonna,
Okay, thank you.
with this is gonna be about
So where's
20.
Phillips Lane on this?
And this side is.
Phillips Lane comes right down.
Well, it comes clear up here.
This will be a little, this side will be a
This
little
will-
more than 20, and this will probably be about 20.
Yeah, looking at this, you know, that straight down here is
Yeah.
about what he's got here for
Yeah.
20.
Correct, yeah.
And then that's gonna be probably 23.
So Phillips Lane's north and south.
Yeah, then it jogs that way.
So what is this he's looking at compared with this? Is it right here? Is that line's gonna be
He
extended?
wants to bring this line straight down.
Okay, and this will be Page and everything over here
Yeah.
will be. Okay.
Now, is Phillips Lane, excuse me, Phillips Lane comes down and it tees. Which is Phillips Lane over
Well,
here?
here's, okay, so everything to the right of
Phillips Lane comes down here.
This is my private driveway right here, so this isn't a public road.
All right.
This is Phillips Lane.
So it comes down, jogs east and comes down.
Correct.
Are you aware if Phillips Lane's public or private?
Yes,
I
we are.
believe
It's dedicated to the use of the public.
Yeah.
Okay.
So, Mr. Chairman, I came up here because we seem to be getting off on a lot of subdivision conversation, and any major subdivision, so any lot of 2 or more would come back before this board at some future time. So if they choose to divide it more than 2 lots, they'll be coming back in front of us. Really, what's before us tonight is just a zone change from RAM to urban ag. If approved, then they would be granted any rights that are associated with urban ag, which is a 10-acre minimum. So didn't want us to get too far off base. And again, their zoning, they gave the reasons for why they believe it met the criteria for a zone change. They'll come back in front of us. Phillips Lane is a dedicated to the use of the public. The property owners absolutely could form an improvement service district, and the county commissioners have grant monies that would help with maintenance, and that currently in place. So if they formed an improvement service district, that'd be a great opportunity for them.
Thank you.
Mr. Chairman, Jason. So going back to 2019, when that 20 acres was approved up there?
Yeah.
I must have missed that meeting. I don't remember that. What was the discussion then? Or how did-
Very similar to the conversation we saw tonight. They believed there was a demand, and planning and zoning recommended approval. Board of County Commissioners recommended approval. It was a increase in need for smaller lots, and it's not a spot zone, it's adjacent to urban ag. That coupled with a larger water line that was installed that serves, has a great more capacity than what is currently there. And the new school being built out there, and just growth in west of Natrona, or west of Casper. I don't know if I'd quite call this western Natrona County, but this is definitely west of Casper.
I wonder who paid for that big water line?
There was state funding, I believe, involved with that.
Yeah, I was a little surprised to see that big a line out there.
Anything else for Jason?
Thank you.
Well, I'd entertain a motion.
For the purpose of discussion, I will move approval of zone change 20-2, subject to the findings of fact presented by staff here today.
Is there a second?
I'll second.
Hal moved, Tom seconded. Any discussion?
number one, I think I'm getting old because I can't remember that previous 20-acre deal up there, but
They wanted
generally,
to put, they wanted to put a whole bunch of houses out there like they're 10.
so generally that would go against my grain that I would think that would be a spot zone. So kind of what we're looking at right now is a spot zone, I think. So I understand that staff's recommendation is to approve?
That's correct.
That is correct. Staff is recommending approval. I'll go back to that map on the spot zone. I don't know if this will help the conversation or not. Because it's contiguous with other urban ag, it would not be considered a spot zone. It's merely progression or growth, if you will, west.
So, aside from all this discussion, I would suggest that staff put this on your hotspot list for the next time we have a. And on the other side of Poison Spider, I noticed just east and north, there's another little subdivision up there that's got apparently smaller lots that I assume are grandfathered in.
Yep, to the north and east of Poison Spider School, there's some
Right.
smaller zoning up there also.
Yeah. That's all I have.
Any additional discussion? We have a motion to approve. All in favor, please signify by saying aye.
Aye.
Opposed? Same sign. Okay, now is the time for public comment. Anyone wish to stand up and unburden themselves, this is the opportunity. If not, I'd entertain a motion to adjourn.
I move to adjourn.
Second.
All in favor?
Aye.
Thank you.
Keith? Hang on a second, can you? Can you hang on a second? I don't know how to turn mine off again.
So go down over here to the little deal right here, press there, and then you'll go up to the little power button.
Oh, I gotta get to the power button.
See? Oh, here's the power button.
Right there. I don't do that at home. My computer's on 24/7.
You guys gonna be here tomorrow?
I'll be here.
Last meeting.
Last meeting.
That's what I said last month.
So you're retiring too?
Oh, yeah, I've been on it 8 years. I had no
You want me to
idea.
look at that before it goes?
Yeah, that's,
I looked at my diaries and I said, 8 years. Yeah, I started in 12.
did you?
That's enough. I'll be 80 next year.
Oh, I'll turn 70 next year, so.
That's enough. We ought to stay on.
No, we want to travel. You just turned 60? 70 much faster than 60.
And there was, yeah, cell tower. I was getting better service along on the way to Chicago. And I think a little bit. Yeah.
He was a land manager there for 15 years. The Permian Basin, southern New Mexico.
No, it's not that way.
Yeah, they're all downsizing.
Oh, yeah. And he survived through downsizing before that. That's even better. Thank you, sir. What's that? Sure. I think he'll be here tomorrow.
Oh, and just so you know too, that when we redid the 2016 development plan, one of the focus groups